Northern Derbyshire Magistrates Court and another.
Good morning, Mr. Reid. Now,
My lords, my lady.
can I just mention one matter before you get launched on your submissions? There are a number of statutory provisions referred to in the parties' written cases which contain references to administrators and to officers of the court. One provision that isn't mentioned in your written cases, but which you, I think, will need to deal with, is Section 212 of the Insolvency Act of 1986. Now, obviously, you're not in a position to deal with this just now, Mr. Reid, and it may, those assisting you may be able to do some work on this in the meantime. But if you can deal with it in your reply, that would be helpful.
Certainly.
But I'm raising it now principally so that Mr. Ozen and those assisting him have some time to work on it. I don't think it raises a different type of point from one that's already being made in the written cases, but it's perhaps the clearest example of legislation differentiating between an administrator and an officer of a company.
Yes, I think within our written case we identified some other examples within the structure of the schedule that draw that distinction as well, but I'm grateful for the indication that we should focus upon it. Before my submissions in reply, I'll make sure that we have a position in relation to it.
Thank you.
Thank you. So, may I simply formally introduce to you, I appear on behalf of the appellant in this matter with me, Mr. McWilliams, and on behalf of the interested party, effectively the respondent to this appeal, the Secretary of State for Business, Energy and Industrial Strategy, my learned friend Mr. Ozing, King's Counsel, and with him Miss Hirsch. This is my appeal against the decision of the Divisional Court of the 12th of November of 2021, itself a judicial review brought by my client against the judgment of District Judge Andrew Davison, sitting in the Northern Derbyshire Magistrates Court on the 29th of May 2018. It's fair to say that there's been a little bit of a long history in relation to the litigation. That doesn't reflect specifically in relation to this part of the appeal, but my lords and my lady, you'll appreciate that there were other points which have been taken in relation to matters. This is effectively the last preliminary issue that remains. There is, in respect of the other points, those have left us at the level of the Divisional Court. My client, Mr. Palmer, is one of 3 joint administrators appointed for West Coast Capital, USC. And at the heart of the case, he is the subject of a prosecution brought by the Secretary of State under Section 194(3) of the Trades Union Labour Relations Consolidation Act 1992 that I'll refer to by the abbreviation TULCRA. His co-defendant in relation to those proceedings is Mr. Forsey, who's the sole director of West Coast Capital USC and also brought a number of preliminary points in relation to matters. At the heart of this appeal is really what's a beguilingly straightforward question in some respects, which is a question of construction. I think when we come to it, we in our respective answers have references to, without disrespect to the judges involved, a thicket of authority, none of which is perhaps none of it is directly on point, and none of it at this particular level. So at one level in approaching this appeal, one can step away from that thicket and approach it with a degree of clarity and I hope a degree of brevity in some respects in focusing upon the issues. So that core issue is what an administrator appointed under Part 2 of the Insolvency Act 1986 is a director, manager, secretary, or other similar officer of the body corporate. And that is the individual criteria against which a prosecution against Mr. Palmer can be brought. And that prosecution relates to the failure to serve on the Secretary of State formal notice of collective redundancies using a form which is familiar to those who practice in this area, known as a HR1 form, providing information about proposed collective redundancies. And in terms of my submissions, I'm going to structure them in effectively three parts. The first is I'm going to give you an overview of our position and not least the problem that Mr. Palmer, and we say not uncommonly, the problem faced by administrators in what is the intersection between two sets of obligations upon an employer in relation to collective redundancy and obligations upon an administrator in terms of their obligations and duties to act in the interests of a creditor as a whole in an administration. The intersection of those respective issues. I'm going to look at the overview of our position in the problem. I'm going to take you at whatever speed obviously you prefer in terms of matters in terms of the sections to the legislative landscape. And the legislative landscape really has three parts to it. There is a directive, a European directive, which remains part of the retained law of the United Kingdom. There are, and I've already referred to it, specific provisions within TOLCRA, including the respective passage that's the subject of this prosecution, and there is, thirdly, the Insolvency Act. So those are the three legislative parts of the landscape that I'm going to take you to. I'm then, in the third part of my submissions, going to develop the specific arguments we raise in our case. And in doing so, I'm going to deal with the authorities to the extent I've mentioned. I'm going to deal with the arguments which were advanced on behalf of the respondent to say that special circumstances is a specific answer to the problems in relation to this case. And I'm going to deal with the suggestion that there is a lacuna in the law left if on our construction we're correct that an administrator does not fall within this particular section. So those are the three broad sections with their particular subsections of my submissions. Can I start off by way of introduction? And I do so by reference to the appellant's case, which begins at page 76 in the electronic bundle. The starting point for this process really rests with obligations about collective labour law. And when we look at the law in relation to it, both by reason of its origin in, or current origin in a directive and in TOLCRA, where an employer, and that's going to be important, where an employer is proposing to make redundant 20 or more employees at an establishment, two sets of obligations are engaged. There's an obligation to engage in a process of consultation and information with the workers, and we'll need to look at the structure and obligations in relation to that, and that has a trigger about the time scales that one starts that process before one starts to implement redundancies. And specifically, for the purposes of this appeal, section 193 of TOLCRA that requires the employer to notify, in practice, as I say, using the HR1 form, the Secretary of State of the fact that they're proposing to make those redundancies, including specific forms of information, and an obligation to do that 30 days before the first of those dismissals takes effect. And the offence arises under section 194 in two parts. There's an offence for the employer, and obviously there may be an employer that isn't a corporate body, and section 194(1) creates an offence for failure to give notice directly against the employer. And for our purposes specifically, section 194(3), which is an offence that rests upon an offence being commissioned by the employer, an offence occasioned by a director, manager, secretary or other similar officer, where the offence of the employer has been committed with the consent or connivance or is attributable to neglect on the part of the director, manager, secretary or other similar officer of the body corporate. And that, as I said, is the offence with which Mr. Palmer is charged. Now, we outline, and effectively before the divisional court, the Secretary of State was forced to concede, and the divisional court articulate that therein rests a fundamental problem for an administrator faced with a set of circumstances. They come to an appointment. Of course, they have an election as to whether or not to accept the appointment as an administrator. They may or may not have had much opportunity to determine the financial position or standing of the business, other than that it's likely, other than by the nature of the fact it's entering administration, it faces insolvency. But they may know little about the detail in relation to the affairs of the business. On their appointment, they owe duties to the creditors as a whole, and those duties to the creditors as a whole are tied around the specific objectives of the insolvency as set out under paragraph 3 of Schedule B1 of the Insolvency Act. And those duties impose the duties on the creditor, on the administrator to act in the best interests of the creditors as a whole. And of course that may include the employees who may be owed wages or other sums, but undoubtedly will represent a wider community than those engaged in the company itself, either its contributors or employees. And in practical terms, that's likely to engage the administrator in having to take swift action. And there's a reason for swift action, and that is the prospect of the administrator being found to have adopted the contracts of workers after 14 days. And in our case, in the notes, in passage paragraph 5, and I appreciate at least one of those judgments will be very familiar to my Lord Richards in relation to the Debenhams retail administration. There's a succession of cases dating back to Powdrill and Watson, a case at the time which caused considerable anxiety and uncertainty for people in this area, relating to what was adopted.
Well, Powdrill really overturned an established practice among insolvency practitioners of writing letters saying we're not adopting the contract and treating that as sufficient.
Yes.
Powdrill said, no, it isn't. If you don't make them redundant, then you've adopted the contract.
Yes. And at one point, although there were consequent amendments made to the insolvency legislation, it appeared even worse than it might at first appear, because at one point the view was that you not merely adopted the contracts going forward so that you had a liability for dealing with the liabilities of wages moving forward, but you also adopted the liabilities for the past.
Yes.
So if people hadn't been paid a substantial bonus or there was some other entitlement that people had, you picked up that liability as well. It was narrowed as a liability, but it remains a significant liability, because if one adopts it, if the contracts are adopted, of course, one adopts them as they stand with the wages and the notice period liabilities in relation to the workforce. So 14 days becomes quite a critical period for an administrator to form a view. Because absent that, and I think it's worth making clear, it's a point we make at the top of page 78 of the electronic bundle. It's just before paragraph 6 in the case. It's a point we make that it's not simply a matter for the administrator, although this will be a matter of concern to them, that adopted contracts and the liabilities in relation to adopted contracts rank in priority to their own costs and expenses. They also rank ahead of the claims of any floating charge or unsecured creditors. So if you adopt contracts and liabilities and they are extensive, it's directly going to impact upon the prospect of disbursement of any assets you realise to unsecured creditors and floating charge holders.
Mr. Reid, can I just say that your references to the electronic bundle, I think we can probably manage in any event, but I'm not getting... did you say page 78?
Yes.
Of the electronic bundle?
Yes.
Right.
Oh dear, I hope I'm not having a panic moment.
No, the 78 is correct for what you referred to.
Yeah.
Just that in the printed out thing we've got, we don't have those. We've
Yes.
got different numbers.
My lady, I'm conscious of that. I'm very happy to give you the page reference for that at the same time.
If you give us the paragraph number, that would
Absolutely.
be the simplest way of doing it.
Certainly, it's paragraph 5.
Just give us a moment, I think, while Lord Burrows
Yeah, I'm
just
sorry.
gets himself orientated.
Yes, thank you. My error entirely, sorry.
But I'll keep an eye on the paragraph. So the adoption point is in paragraph 5 of the... I took you to the end of paragraph 5, which is on 78 of the electronic bundle. So that's an administrator's view in relation to adoption. By contrast, if, when we look at it, one follows the obligations in relation to TULCRA, at the least, one would not be able to implement any dismissals or affect any dismissals for 30 days, so far as the notice to the Secretary of State is concerned. And indeed, when we look at consultation obligations, 30 days or 45 days in relation to those particular obligations under the workforce obligation. Now, obviously, both of those timescales sail past the 14-day adoption period. So we identify that the administrator is placed in a difficult position. Do they have regard to their obligations to act in the best interests of the creditors and act in a way that causes the company to be in breach of, as the employer, of its obligations collectively to the workforce and also to the Secretary of State? And if the Secretary of State is right in relation to this prosecution, expose themselves to the risk of criminal offence? Or do they continue potentially to employ the workforce, even though they adopt the contracts, and reduce ultimately, potentially, the amount of money distributed to the creditors in respect of whose interests they act? And I hope it's helpful to give an example, not directly alluding to a case, but of course one of the cases we already referred to, the Debenhams case, has a sort of similar history to it. If one imagines this type of scenario, one has a large retail company that has shops, it has warehouses, it has a head office with all the necessary administration. It also has an online presence. one can imagine that an administrator appointed in an insolvency, in that type of situation, might see certain choices. Not untypically, they might look at head office and think that much of the structure of head office and those engaged in there, many of whom will be the highest paid workers in relation to the organisation, do not reflect the interests of creditors if their contracts are adopted. And they immediately make redundancies in head office, specifically senior management. There won't be a need, they think, ongoing for the level of warehouse structure or supply chain, and they make closures and redundancies there. However, consistent with the rescue culture, they may specifically see that there are particular advantages in selling off maybe the online presence. That might be an identifiable business, part of the business, which could be readily realised. And there you could see that they might form the view that adopting the contracts for those engaged in that particular area is in the interest of the creditors, because it makes it easier to package and identify that part for sale. Now, those are decisions which have to be made with the degree of urgency. And contrary to that, as we say, the unpalatable alternative is to, unpalatable so far as the creditors is concerned, hold fire in relation to any action, continuing to pay the salaries of those in head office and in relation to the warehouses, even though their functional utility for the business may have diminished and not be continuing. And what options might there be for an administrator faced with this dilemma? Well, of course, one obvious option, and this case and the prosecution that arose was a matter of considerable interest. I think over the passage of time, possibly due to the time that this case has taken, interest in it has ebbed and flowed in the administrative community. Sometimes people forget the existence of this as an ongoing piece of litigation with important consequences, but there's no doubt that as a point it raises considerable anxiety amongst the administrator community, because what options would there be? Well, an option which presents itself as the alternative is to decline the administration and adopt the alternative route in the context of insolvency of placing the business in liquidation. And we, at paragraph 10 in our case, give some thought to that, not least because it has certain consequences. Although I acknowledge that it's not the case that it will always be an automatic termination of the contracts of employment of those working in the company, typically the conventional wisdom is that in order for the winding up of the company by way of liquidation would terminate. And indeed, that would mean, ironically, that all of the purposes underlying this would ultimately be frustrated if one thought that the safer course, rather than risking prosecution or committing a criminal offence, was allow the company to go into liquidation, because A, one would find that there would be an immediate termination of the workforce potentially. So any of the possible advantages that might have arisen about consultation, trying to avoid redundancy, would disappear. And the Secretary of State would find that there would be an immediate dismissal without the notice which the section contemplated being given. So the purpose underlining that of being able to take steps in anticipation of the collective redundancies would also be thwarted.
Can I just ask you this? In that last sentence of paragraph 10, you say that where a company is placed into compulsory liquidation, the conventional view is that all employee contracts are automatically terminated. Now, two questions. The first is, you specifically refer to compulsory liquidations. What's the position in a creditor's voluntary liquidation?
The historically, there's case law to the effect that that also terminates the contracts of employment of the staff. I acknowledge that there are cases where liquidators have been considered to have conducted in liquidation the affairs of the company, so that they have continued the contracts of the staff. But creditors, but
anyway, you say that the same principle applies to both types of liquidation. Yes. And secondly, I mean, very briefly, what is the basis of the notion of automatic termination? What is the conceptual basis for saying that there's an automatic termination?
I think the conceptual basis is that the order is causing the employer to cease to exist. I appreciate that it doesn't happen immediately.
No. Anyway, all right. Anyway, that's the conventional view. Anyway.
Yes, I'm not. And when one looks for the notes to the conventional view, it's right to say that a lot of the case law is quite old.
Right.
And as I say, it's not. There are some describe it as being the modern view of insolvency in relation to liquidation, that it's possible for a liquidator. I can think of a quite well-known liquidation where special managers were appointed.
Well, I mean, that's different. I mean, you could have clearly the liquidator could, as it were, re-engage staff whose contract has been automatically terminated.
Yes.
I mean, that might have employment law consequences for their rights under their contracts of employment. But so there wouldn't be any conceptual difficulty about a liquidator re-engaging staff where he thought it was, or she thought it was appropriate. But I was just interested in the notion of an automatic termination.
Yes.
But anyway, you've given us a reference there, and I don't pursue that further. Thank you.
It is worth in the notes there just following down one line of one of the consequences. It's a side consequence of the protections for the workers. I've mentioned that. Obviously the purpose of consultation and the Secretary of State would be frustrated if one went down that particular route. Typically, in the scenario that I've identified, one of the protections that the workers enjoy is the application of the Transfer of Undertakings Protection of Employment Regulations. And those, if you sell part of the business as an undertaking, they are engaged in a way that provides that where the workers are transferred from their employment to the new employer, their contracts are preserved, and there's an encircled protection around them that provides that if they're dismissed because of that transfer, they're deemed to be automatically dismissed. But one of the quirks of the transfer of undertaking...
Automatically unfairly dismissed, or just... Sorry, that if they're... So their contracts transfer, and say again what...
Oh, I'm sorry. There are two bits of protection. Their contracts transfer, yes, and they're treated as if their contracts stand, yes, with the new employer, same terms. But if in that process they're dismissed, there are various ways of doing it fairly, but if in that process they're dismissed, the transferee just refuses to take them, then under the TP regulations, their dismissal is deemed to be automatically unfair. Right. And if they have unfair dismissal rights, they can bring them, importantly for them, against the solvent purchaser who declined to take them. The only reason I mention this is that if your lordships go with me from the footnote to the regulations, that's at page 433 of the electronic bundle. We have two regulations here, Regulation 7 and Regulation 8. I should, on reflection, perhaps have included Regulation 4. Regulation 4 is the regulation that preserves contracts of employment. Regulation 7 is the regulation that I've just mentioned, which deems a dismissal because of a transfer unfair. The reason I've taken you here is that if you go to 434, under Regulation 8, there are specific provisions dealing with transfers in the context of insolvency. And under Regulation 8, subparagraph 7, it provides that regulations 4 and 7 do not apply to any relevant transfer where the transfer is the subject of bankruptcy proceedings or other analogous insolvency proceedings which have been initiated with a view to a liquidation of the assets of the transferor and are under the supervision of an insolvency practitioner. What that means is that employees who might find, even in a liquidation, that there's a prospect of part of the business being sold off, aren't entitled to the protection of the transfer of undertakings regulations, whereas in the context of administration they are. I should mention, we perhaps don't need to spend very long in relation to it, there was a period of time a few years ago where it was thought that the regulations didn't apply to administration either, but it's been clear now, certainly at the level of the Court of Appeal, that it's only liquidation. So I identify that.
Because an administration is not instituted with a view to the liquidation.
That's exactly right, because one of the purposes under when we come to look at it, paragraph 3 of the insolvency schedule, identify the prospect of liquidation as being the last resort in terms of assets.
I suppose if a company is put into liquidation, then the employees are going to rank as creditors.
Yes.
And their claims have to be quantified to rank in the liquidation. So they're going to have to be regarded as crystallised claims.
Yes.
Which isn't possible if the employment relationship is regarded as continuing, whereas in an administration there's no need. Obviously, there's no parallel process of distribution, and so there isn't the same necessity to treat the contract of employment as terminated.
Yes. I take that point. I suppose my point was to similar effect in terms of, that's a point from the protection in terms of their entitlements being crystallised. My point was really about their protections in terms of securing their continued employment. Yeah. That someone who takes, if in my example, the creditor faced with the risk of adopting the contracts for the insolvent retail business said, well, I'm not going there, and we'll simply place that company in liquidation, whether or not it's creditors' voluntary liquidation or whether it's compulsory liquidation, whether or not the termination of the workforce is there. If part of the assets sold off related back to the intellectual property rights of that online retail, none of the workers who worked in that particular area will be able to say, I have the right to go across and have my contracts preserved. So that dichotomy between liquidation, the traditional insolvency model, and administration, with all the advantages which were perceived to exist in relation to it so far as the rescue culture was concerned, is a stark choice, as we perceive it, for an administrator faced with the risk of placing themselves at risk of criminal prosecution. So I've taken time to outline that problem. It's a problem which lies at the heart of this case. And it's a problem to which we, in essence, have a simple answer, which is that we say that when you look at the section itself, a administrator is not a individual that falls within the definition. They are not, to take the end of it, a similar officer of the company. To put it in one sentence, they have authority over the company, but they're not of the company. They're not appointed by the company in the sense of being within its own terms and powers. They're not answerable to the company itself in terms of its responsibility or its contributors. they're answerable to the creditors and ultimately the court for whom they are an officer. So that in essence is the core of what we say. None of the cases really help you, we say, specifically with looking at that particular meaning when it comes to the definition of the section. That was really by way of introduction.
Can I just ask this in the light of what you've just told us about the important distinction between liquidation and administration?
Yes.
I take it that there would be no question of a liquidator being regarded as a similar officer of the body corporate.
Well, I think my learned friend's position is that a liquidator would be regarded
Right.
as being. We obviously take the same position that a liquidator would not be.
Right.
And I think there's a footnote to a case which he refers to where my Lord Newburger was a judge at first instance, where he hears an argument referring to a similar definition in relation to another context and makes the assumption that a liquidator was within the scope of that definition, although does not decide the point and in fact deals with it. We can go to the case, but our position would again be quite straightforward. We again would say that a liquidator is not of, but has authority over the company to discharge their responsibilities.
But in the case of a liquidator, there wouldn't be the same dilemma between, if he is an officer of the company, between the 14-day deadline for adoption of contracts and the 30-day minimum period for giving notice of redundancies.
No. They wouldn't have the same concern about how they would have taken on liabilities which ranked as a super priority within the administration itself.
I think one of the complicating factors, if I recall it, is that in the Companies Acts, which of course used to include all provisions relating to corporate insolvency, which they haven't since 1986, officer was defined so as to include a liquidator.
That's correct. And in fact, I think it's, again, it's the extent to which this helps. I take the same position in my learned friends' cases as I do with my own, in a sense. We refer to the case of B. Johnson Builders, which concerned, which was in the days in relation to insolvency in respect of actions by what was then a receiver and also a liquidator. And a claim was brought alleging misconduct in relation to those. And the liquidator was unable to argue that they were not the subject of an action because they were specifically included in the definition, whereas the receiver was able to succeed in an argument that they weren't caught by the definition.
Yes.
Obviously, since '86, we've had this
Yes.
parting of the ways.
Yes.
In our case, it's paragraph 13 and page 80. We refer to the legislative framework. I was going to take you to the relevant sections so you can see the structure of things before we come to the respective parts. For those purposes, can I begin by taking you to the directive? And you find the directive at page 305 of the electronic bundle. And just by way of observation in relation to the directive, this is in fact the second directive that was made in the field of the approximation of laws in relation to collective redundancies. The earlier directive, which is mentioned in the recital, was made in 1975, 75129, and that was then subject of a new directive on 9859, which remains the current directive in relation to matters. I should mention, and again, it's one of the points that appears in some of the cases in relation to this, as an area of the law, it's had a little bit of a checkered history in that when we look at domestic consultation, we don't need to worry too much about this. Actually, its ancestry predates any European directive. Its origins lie back in 1975 and required an obligation to consult with a recognised union if only one employee member was being made redundant. And that proved the basis upon which various amendments were made over the years. Amendments have progressively been made throughout the period to the modern format of the Trades Union and Labour Relations Act. Some of the cases reflect passages which appeared at particular points in time. One of which I mentioned in passing, which my learned friend makes reference to. He refers to a case called Hartlebury Printers about collective consultation. And one of the points at that point in time was that the original directive expressly excluded collective redundancies which had been occasioned by reason of judicial decision. And that was removed in the 1998 directive and left to the discretion of member states to the extent that they made modifications to collective redundancy where there had been redundancies resulting from judicial decision. We'll see that when we look at the text, but that's something that we've never taken up so far as the UK is concerned. But again, I mention that because the history of the legislation means that there are consequences that sometimes cases are at the particular formulation of the wording at that particular point in time. What is true, and we'll come back to it when we look at special circumstances, is that that phrase has been there throughout and is used in both forms of stage, although it doesn't actually appear in the directive itself.
Okay, just to be clear, a failure to engage in the consultation exercise is not an offence, am I right? It's only the failure to give notice to the Secretary of State which is actually made an offence.
Yes.
So I mean, that's what we are directly concerned
That's
with.
absolutely right.
Yes.
We won't spend long on it, but for clarity, there are two routes of the engagement. One is an engagement towards the workers.
Yes.
And their existing representatives, which might be a recognised union or elected representatives, or a process of electing representatives.
But none of that leads to an offence.
No, it leads only to the prospect of a claim in the employment tribunal for what's called a protective award.
That's what happened in Clerks of Hove, is that right?
That's what. Well, in the end, it's what they wanted to bring in Clerks of Hove. That's exactly right. So the union wanted to bring the claim in Clerks of Hove for that protective award in the employment tribunal. Because of the existence of the insolvency, they needed the permission to do so, and the merits of that claim were being considered.
Is there anything in the directive which suggests or requires that member states should create criminal offences?
No.
So is it going to tell us anything about the issue which arises in this appeal?
The only two things that it can, well, the first question to answer about that is the only thing that it tells us specifically about obligations in enforcement is Article 6 on page 307. And Article 6 directly imposes an obligation on member states to ensure that judicial and administrative procedures for the enforcement of obligations under this directive are available to workers' representatives and or workers. It doesn't specifically refer to an obligation to impose any methods in relation to the notification of any public authorities, competent authorities.
There's nothing in the directive which requires notification to public authorities.
There is.
There is,
That's
okay.
Article 3.
Oh, okay.
Just very briefly.
Oh, I see. Article 3.1, yes.
The obligation there is on the employer.
All the obligations are on the employer. There's no obligation under the directive which isn't engaged on the employer. So very briefly, Article 1 defines a collective redundancy. Article 2 sets out the information that has to be provided to the workforce. And collective redundancy is engaged where an employer is contemplating, we actually use a different word in the UK, but is contemplating a certain number of redundancies. Article 2 sets out the obligations in relation to the provision of information. And in the directive, these things are integrated because in the directive, at Article 3, there's a specific obligation to notify competent public authorities in writing of any projected redundancies. And then there's separately the obligations about consulting with the workforce. But the direct answer to your question is that there's no obligation to create a criminal penalty around the notification of competent public authorities. And in fact, so far as there's an express obligation about remedies and enforcement, the obligation is directed towards providing those remedies for the workers and all their representatives, which in the UK we do by providing for their ability to bring claims for protective awards in the Employment Tribunal.
And Article 4.1 gives the 30-day notice period requirement. But it goes on to say that member states may grant the competent public authority the power to reduce the period. Did the UK take advantage of that?
We adopt the 30-day...
without giving the Secretary of State power to reduce the period?
There is a power to reduce some of the... I should be clear. The notification periods in relation to collective redundancy to the workforce are longer than 30 days. The triggers there are, if it's more than 20 but 100 or less, you have to notify 30, you have to start the consultation 30 days. If it's more than 100, you have to start 45 days. It used to be 90 days, and the Secretary of State reduced that, but the Secretary of State's never reduced the notification period. For notification, it's always been 30 days.
To the Secretary, yes. Okay, thank you. And the special circumstances provision in the UK, in the domestic legislation, is that reflected in? Does that reflect something in the directive?
No.
No.
No. As I say, it's always been domestic law. It's continued in domestic law, but it actually isn't. Heralded specifically in the directive. I would mention it may not have caused a concern on a community level because our compliance with the directive has been the subject of proceedings by the Commission twice during its history, and we've made modifications to the legislation as a consequence of that in the past. And so far as I'm aware, no issue was ever raised about the existence of a special circumstances defence. And I'm confident about that because in the Carillion case, my learned friend refers to, where I appeared for Carillion in the case involving special circumstances there. The union sought to argue that special circumstances were not compliant with the directive, and the E80 at least had little trouble with that. But there isn't any specific provision about it in the directive. So the directive is quite open in its texture, and it's right, and my learned friend makes reference to this, that this is not a compulsory harmonisation provision, because Article 5 on 307 provides that member states can provide for more favourable to workers or promote to allow the application of collective agreements more favourable to workers. So
it sets a minimum standard.
it sets a minimum standard.
So the provisions with which we're concerned, as I understand it, the offences with which we're concerned, have their origin in the Employment Protection Act 1975.
They were originally there, yes.
With the defence of special
With the defence of special circumstances.
Because those were the provisions in Clerks of Hove.
Correct. Yes.
And that's the first time that this offence was created. Well, there was no predecessor legislation to the 1975 Act.
I'll double check that, and I did go back over all the history of this for the Carillion litigation.
Right.
I believe that was the first time it was created, and it wasn't created, as I articulated, to give effect to the directive.
Well, that's what I was going to ask you there, because the directive is 1975 and the Act is 1975,
Yes.
but the Act was not by way of implementation of the directive.
No, and it reflected a different attitude at the time.
Okay, and then there's no intervening legislation between the 1975 Act and Tulcra.
No, which is a consolidation act, and then Tulcra was modified progressively over the years.
But no, not in any way directly relevant to what we're concerned with.
No, none of the parts that we're directly. Mr. McWilliams makes a point which I'd neglected, that the 75 Act didn't include a liability for officers.
But I think it did.
I
think it. I had a look at it. I think it was the offence that the company, the employer, committed was under Section 105, but the directors, etc., were made liable under Section 117.
In that case, I'm sorry about that. Bad point, I withdraw.
Don't worry.
But yeah, so I'm sorry that your question was completely accurate. That nothing intervenes, Tulcra comes in, but we can trace the ancestry of this criminal offence back over that passage of time.
Yeah.
And the directive is adding obligations in that we've changed and dealt with, primarily about raising the barrier about when you had to consult, because originally in 1975, as I said, one employee by a recognised union required you to consult. Now, it's a minimum of 20 at an establishment that's engaged by those provisions.
And it wasn't as if the provisions of the Employment Protection Act 1975 were anticipating what was going to be in the directive, you don't think either? It was just
I think
entirely separate domestic policy being pursued that happened to tie in to some extent with the later EU directive. That's
Around consultation.
That's how you're submitting the position.
Yes.
Yes, thank you.
And that's reflecting, if one casts one's mind back to the mid-1970s, industrial relations were, I hesitate to say more vexed than now, because actually they seem pretty vexed at the moment, but that's a different point. But at the time, there were waves of legislation looking at trying to deal with the particular in relation to unions. And it was, the 75 Act was very much a piece of legislation engaging consultation with one employee, directing its protection around recognised trades union in that respect. So it had a freestanding position. Now, of course, it's also right to say, and my learned friend makes this point, that the structure of the offence and special circumstances, all of that predated the emergence of the rescue culture and the insolvency legislation. That the framework at that particular point of time would have been liquidation or other forms of insolvency mechanisms, such as the appointment of receivers. But the legislation tracks through to that original point. I was going to leave the directive then and just take you to the Trades Union Labour Relations Act. That's at page 277 in the electronic bundle. Um, 277 is the beginning of the section. It's chapter 2, procedure for handling redundancies. And we don't need to spend any length of time other than to point out some similarities to you between the two parts. So here it's broken down, like the 1975 Act, into two elements. There's the duty of the employer, always the employer, to consult with representatives, and that's section 188. And you see the two trigger conditions that I've mentioned there, whether or not it's proposed to make as redundant 20 or more employees, that's little 1, and whether or not at little 2, whether or not it's proposed to make 100 or more, little 1A, whether it's proposed to make 100 or more employees redundant. And those timescales are that the employer, if they're proposing to dismiss in that window, is required to consult with the representatives, which may be a recognised union, may be an existing work body, may be elected individuals. And the phraseology is they've got to begin the consultations in good time, but in any event, not less than 30 or 45 days. That's where there was a reduction. And there are obligations about the provision of information to the workforce for those particular purposes. And what there is in regulation in section 188 is at subparagraph 7 on page 279, we find the special circumstances defence mirrored in the same terms as we later see it in the criminal offence. And that's what Clerks of Hove was specifically considering in its original form in 1975. There's been one change to it about which we draw some observation. So subsection 7 says if there are any special circumstances which render it not reasonably practical for the employer, and it is the employer, and when we look at the subsequent criminal offence, it's the circumstances that render it not reasonably practicable for the employer, rather than the administrator or anyone controlling when we look at the criminal offence. To comply with the requirement of this subsection, that's the first part of the offence. If you establish that, you may be able to avoid the liability for your failure to comply, other than that you have to still take all such steps towards compliance with that requirement as are reasonably practicable in the circumstances. So
although it's referred to as a special circumstances defence, it's not really a defence. It's really a circumstances in which the timetables set earlier in the section are modified from being not less than however long to being what's reasonably practicable.
Yes. And so to give a practical example, which people often give of what might be a genuine set of special circumstances, I have a large retail premises in the middle of Manchester, and unfortunately fire breaks out and the entire premises are burnt down over a weekend, with the result that I have no prospect of continuing to trade. I have to make the workforce immediately redundant. One could see that would be not only a set of special circumstances that might have interposed in relation to my ability as an employer to reasonably practically consult more than 30 days, but also if I didn't do more than tell the workforce, well, I'm afraid I'm going to have to make you redundant, I might equally be able to say that I'd taken such steps as were reasonably practicable to comply. So you're right, everybody calls it a defence, possibly a misnomer, in that it's really a modification of your duties. And in principle, you will always be left with some level of duty, even if it's a relatively modest amount of
Yes,
duty.
I mean, it was treated in Clerks of Hove, essentially, if you like, as a defence, in the sense that the burden of establishing it was treated as being on the employer.
Absolutely.
Is that the same
It's
in
still
a
the
prosecution?
The
Or does the prosecution have to establish that there were no special circumstances? I mean, I can see an evidential burden may move, but...
Sorry, can I have a moment to reflect on that? Because in the context of collective redundancy and the workforce, the rules specifically provide that the burden is upon the employer.
The rules provide that.
The section, when we look at, we perhaps only do, but the sections provide in relation to the remedy of protective award, the obligations rest upon the employer to show compliance. Once you've triggered the liability of the dismissals, the employer has to show the compliance with the election process, and so the burden is clearly on them for them to show special circumstances.
In order to avoid having to pay the protective award.
Correct. I'm not sure that
Actually, of course, the special circumstances isn't included itself as a defence to the criminal charge. No, I see. So.
Well, it's included in the. It is included as a defence for the company.
Sorry.
It's not included as a defence for the individual.
No, well, I follow that. Yes, I see.
Yes, it is included for the company as a defence.
It is. I'm sorry.
In the same wording, but it doesn't provide the same guidance as to where the burden would rest.
No, sorry. I mean, under Section 193, that's the obligation to give the notice to the Secretary of State.
That's
which
287, I think, isn't it?
Yeah, 193 starts at 285.
Yes, sorry.
And goes on to 286. And what it is it's a qualification on the duty.
Yes.
I mean, the duty prima facie is to give the statutory period of notice, but where there are special circumstances, a substitute duty kicks in.
Yes, in the same way as the other provision. So the substitute became, so if they're shown you haven't got the duty to give 30 days notice, but it would follow logically in the same way as the consultation obligation that you've got a duty to give such notice as will be reasonably practicable in the circumstances.
Yes, so on the facts of this case, for example, where the administrator forgot to send the form to the Secretary of State, he might well still have fallen foul of this reasonably practicable timetable, even if the primary obligation for the 90 days or the 45 days or the 30 days had been modified because of special circumstances in subsection 7.
Well, I'm obviously conscious not to say anything that places my client in a job, but I take the point.
In a hypothetical situation.
In a hypothetical point, I absolutely take the point that because of the two-stage element of it, number one, if you pointed to the circumstances as being special, you'd still need to show that you had taken what was reasonably practical. And it could be said that if there was something that meant that you could have done it, but were unable, but for some reason which was your fault you didn't do it, then you can't take advantage of the particular defence, if defence is the right term in relation to it.
But it's really, as my Lord Hodge said, it substitutes a different timescale or a different duty for the duty in the first subsection.
Yes. I think I was answering a question about burden, and I was just checking. I don't think, unlike in the collective consultation with the workforce, I don't think there is any specific provision directing the burden where that would rest, although no doubt it would be said probably by the prosecution, that if you're looking to modify a duty, then it rests with you to show those circumstances exist.
Anyway.
I've taken you, I took you to collective redundancy at 188, and you've rightly taken me to 193, which is really obviously the heart in relation to matters. Before we just focus on 193, just so you're aware of the context of it, because obviously there's an issue even with the collective redundancy where an administrator will recognise that they're failing to comply with their obligations in relation to the workforce. What typically happens there is a protective award claim, and the protective award claim ultimately, if there aren't funds, is met by the redundancy payment fund to a limited extent, subject to cap. So that's why you typically see in insolvent situations those claims still being brought by the workforce. And of course, noticeably, in terms of their enforcement mechanisms, where in the directive there was an obligation, that they're all still to an extent secured in that particular environment. But 193 is at 285, and 193 adopts, as we've already considered, the twofold previous time bracket of 30 days and 45 days. As I indicated, it used to be 90 days. But the 90 days was amended, and we haven't gone lower than the positions in relation to the directive in respect of notification. So 193 imposes a duty, and 1937, subparagraph 7, replicates the special circumstances that we've seen in collective redundancy. And if one looks at the offence at 194, one doesn't expressly see the special circumstances being replicated. So I think the strict answer to the question is that special circumstances modify the original duty, and in its modified duty, it would be a criminal offence for the employer not to comply with any modified duty reflecting the special circumstances, but it's effectively not directly articulated here. And I've already made the point about special circumstances that because of the secondary nature of the offence alleged against my client, any focus is always on the employer. So the fact that he is an administrator doesn't give him a special position in relation to the standing in respect of that. The question of special circumstances will be looking at the special circumstances around the employer. But
So you're accepting that one cannot use the special circumstances, in inverted commas, defence as a means of getting the administrator off the hook, qua administrator, if the administrator is indeed an officer.
yes, I have to be careful about that. I'm not saying it's not open to argue special circumstances for administrator, because there may be perfectly proper examples of cases. For example, the fire, where the corporate entity that operated the shop might immediately be put into administration.
Yes, but it's not because of the administrator's particular problem about the 14 days,
No.
the adoption of contracts. It's the nature of the circumstances in which the insolvency occurred, as set out in Clark's Approve.
Yes.
That you may get a sudden event and no one could do anything about it, or you may get macabre-ish behaviour by the directors when there's a slow-motion car crash, namely the insolvency.
Yes. So, and in a sense, it probably makes sense to deal with my learned friend's special circumstances argument now in answering that. So what you say is right, and I'll break it down in these two parts. Special circumstances is open as an argument, but the circumstances have to be the circumstances of the employer.
Yes.
And the circumstances of the employer, in the case of administration, is that it is in administration and potentially therefore insolvent. But what Clerks of Hove tells us, and we say that that's long settled law and really makes sense on the wording, is that special circumstances contemplates something special. The Court of Appeal there articulating it as being something unusual or out of the ordinary. And the existence of an administration isn't of itself unusual or out of the ordinary.
Well, it is for the company in question. I mean, most companies only go into administration once, and most companies never go into administration. So,
yes.
I mean, it's a little bit strange to think that administration isn't a special circumstance. But, of course, the real question is, isn't it, when is the proposal to make employees redundant formed? So if if a company goes into administration and it is only then that thought is given to whether employees should be made redundant, then, I mean, there must be good reason to suppose that the administration is itself a special circumstance, because it brings in its train all the points that you have made about the pressure on the administrator. By contrast, of course, if the directors have been planning redundancies for some time before it goes into administration, then that's a different situation.
Yes.
Because it's not the special circumstance of administration that has prevented notice being given. It's the failure of the directors having formed their view that this is what they're going to do, their failure then to give notice.
Yes, although, and I'm careful in relation to where I progress.
Because in other words, in some circumstances, even though the administration may be regarded as a special circumstance, it isn't causative of the failure to give due notice.
Well, I suppose there's a point which remains extant in relation to this, which is where the offence specifically is crystallised. Because suppose if the employer, so if you look at 193 at 285, so there needs to be an employer proposing to dismiss.
Yes.
But the obligation is to give that notice a certain period of time before giving the notice to terminate, or before the first of those dismissals takes effect.
Yes.
So is the offence, if the dismissals don't happen, is the offence crystallised by the original proposal, or is when the dismissals happen, it offence at an earlier point in time when the employer had those proposals but insolvency intervened and the administrator had to act in the particular circumstance?
Well, it would depend on the facts of the case. But I mean, broadly speaking, the employer proposing to, I mean, the section says the employer proposing to dismiss as redundant the relevant number of employees shall notify the Secretary of State in writing of his proposal. And they've got to do so, having regard then to those time limits. But the point I'm making is that the critical factual issue is when can it be said that the employer is proposing to make redundancies? Now, that could occur before the company goes into administration. For example, you've got a planned pre-pack, which you then appoint the administrator to execute within the following 24 hours. Or you may have the case where there has not been any prior proposal by the company to make employees redundant. An administrator is appointed, and then he has to make the decision.
Yes.
In that case, I find it difficult to see why that isn't a special circumstance.
Well, obviously, from my perspective, I've argued the case on the basis of the law as it stood in relation to Clerks' Oath, which of course this court isn't bound by. And Hartlebury.
But I mean, both Clarks and Hartlebury make clear, really, that you can't say. I mean, you might have an administration which is not going to involve redundancies.
This is true. Yes.
So you can't say necessarily. I wasn't trying to suggest that an administration is always a special circumstance, but in many cases it may well be. So it's a question of fact, isn't it?
Well, I don't...
In the sort of case that you have been putting to us, which is where the company goes into administration without there having been any sort of significant pre-planning by the directors, goes into administration, immediate decisions like in Debenhams and so on have to be made. I mean, for the life of me, I can't see why that isn't a special circumstance.
I see the force of the point. I suppose my difficulty is that so far as this prosecution is concerned, clearly my focus is on whether or not the administrator is outside the scope of the legislative.
But no, we've got to come to that. That's very important that you do come to that. But this is an important point as well, because it goes to whether the two pieces of legislation create an impossible dilemma for administrators.
Yes. Well, it does. Can I answer in these terms? Is that it still creates the dilemma that the administrator may be faced with a set of circumstances where they expose themselves to criminal risk in circumstances where it's a question of fact as to whether or not the circumstances are engaged, particularly if they prevent the dismissal. Because does that mean that before they put themselves in that dilemma, they have to ascertain quite carefully whether or not there were any concepts of proposals in the minds of the directors before that mean that they expose themselves to criminal risk when they affect the dismissals, because that's the bit that crystallises arguably the offence. I think it's also right to be careful about the word propose. And the reason I'm careful about the word propose is you'll recollect that in the directive, it actually uses the word contemplate. And in the UK, we've always used the word propose, there's clear authority for the idea that it's a later in the process. But at the level of...
But it's got to be more than just kicking the idea about, hasn't it? I mean, you've got to come to a reasonably firm decision.
That I wouldn't disagree with, but it can be a decision to do something for which redundancies might be an inevitable consequence.
But the fact that the directors have reached a proposal but failed to give the notification doesn't mean the administrator, once appointed, will be liable for the offence, because the administrator can only be liable if the offence has been committed with his consent or connivance, or is attributable to his neglect. If he's appointed and carries out the director's plan to make redundancies, which have to be done within 48 hours, and he immediately pings off an email to the Secretary of State giving notice, he surely has done nothing wrong, if I can put it like that. That doesn't mean the directors are not still liable for the company's failure to give notice rather earlier. Well,
I take the point that there is an issue in relation to directors if they had a proposal.
I mean, before the administrator can be liable, he or she personally must have consented or connived to the breach, to the failure.
Consented, connived,
or be attributable to their neglect.
To neglect on their part.
Yes.
I absolutely accept that.
And that necessarily can only be something that occurs after their appointment.
Yes, because prior to their appointment, they have no authority to act.
Exactly.
Yes.
But the reality, and I don't want to talk about this particular case because I know a director is facing proceedings, but take a typical pre-pack,
yes,
where a company may have 3 factories, 2 of them are deemed by the directors to have long-term viability, 1 is not. What will normally happen, will it not, is that the directors will speak to insolvency practitioners who are potentially to be appointed as administrators and work out a scheme, a pre-pack, where you have a preferred buyer who is maybe a subsidiary of the same group or maybe an independent third party, and you'll work out a set of proposals which, well, from the moment the administrator is appointed, is a tick list which you go through, which has been agreed by the directors on the advice of the insolvency practitioners, who at that point become administrators. But what they've done beforehand, you would say, it's certainly not taught by this provision, because on any view they are not officers of the company when they are giving advice. But they nevertheless will be people who will be fully aware of what it is the directors are proposing, because they are essentially implementing a pre-pack.
Yeah, I entirely agree with that, because, and it's partially a consequence of the 14-day window, that and the desirability in some cases of creating a PPAC to shed debt, that these things are quite often the subject of consultation with the administrators as part of a plan that means that they are implementing, they hit the ground running, and the sort of decisions that I've contemplated are not decisions taken ad hoc in the context, but reflect a previous view. But the minute they do step into that position, yes, unless I'm right about the construction point, they're immediately in the frame for that element of risk.
The offence is being treated as if it's a continuing offence. So every day between the moment of the proposal and the duty crystallising to give notice until notice is given, every day is the commission of a criminal offence. And that can then be, the offence is committed by the director from the date of the proposal up to the date the administrator is appointed, and then by the administrator from that point until notice is given. That seems to be how it's treated. But that treatment of this as an offence being committed each day, then the difficulty with, well, what happens if the special circumstances which modify the time scales arise during the course of those days? That seems to me a conundrum with how you suddenly modify the timescales in the course of days on each of which the offence is being committed. Suddenly then it's not being committed on the later days, or because the special circumstances have intervened. It seems to be conceptually quite difficult.
Yes, and I think that's a fair point in this sense, that to go back to the example given by my Lord Richards in relation to whether or not the administration is itself as a unique event for the company special. If you looked at the position before, and obviously I'm not on behalf of the director, and I articulate only this for the purposes of dealing with the argument, but before the appointment of administrator, and it may be that the prospects of insolvency are there, but clearly to the extent that insolvency is described as a special circumstance, it didn't exist. And it's only the decision to appoint the administrator that puts it in that particular regime at that particular point in time. And then the administrator steps in to that particular environment. And obviously there is a difficult question then between the special circumstances you articulated as to how that works in that particular context, because it's not quite the same situation as my rather simplistic example of the fire, where we have a single intervening circumstance event that crystallises in time at a particular point in time. More difficult as well if you look at a business that might be floundering. At what point do you decide that rescue is not possible? That was exactly what happened in Clerks of Hove, where the facts indicated that there were various plans to try and rescue the business, and ultimately one particular potential purchaser pulled out late in the day, having seen the accounts. And there was an attempt to argue that that was a special circumstance that failed in relation to that particular case. So to go back to your question, I don't disagree with the proposition that special circumstances might exist in the insolvency situation. I'm slightly questioning with respect to the idea that it will always be a set of special circumstances. Special to the company, undoubtedly, but special more generally. And that is it something unique and out of the ordinary in a more general sense?
Well, I mean, there are two ways of looking at this. You can ask yourself, is going into administration a special circumstance? Or you can accept that it is and then go on to ask, well, does it render it not reasonably practical to comply with the requirements? And if it is proposed to make some redundancies, well, if it's not proposed to make any redundancies, then, but later there's a decision to do so after the 14 days have passed, well, it probably isn't. It probably is reasonably practicable to give the relevant notice to the Secretary of State. So it just depends on the circumstances. So the really important thing is not so much whether it's a special circumstance, as or equally important is whether it renders it not reasonably practicable to comply with the notice requirement.
Yes. Although special circumstance must have...
It must exist. I mean, you've got to have it, I agree.
They've got to exist.
Yes.
And it must have conception about it. Yes. Whether or not it's right to articulate it as articulated in Clerks of Hove as meaning something unusual or out of the ordinary.
Well, I mean, Mr. Justice Morritt did address this in the Hartlebury case, and he said, well, the fact of administration itself is not inevitably a special circumstance, but there may be other circumstances, such as ones which have been raised in this discussion, which do make it special circumstances.
Yes, and as I said, I don't, and if I'm unsuccessful with my primary argument of construction, I can well imagine me seeking to argue special circumstances. So I'm certainly not going to abandon it as a set of factual criteria. My point is more one of primary principle. What is clear in Mr. Justice Morritt, as he then was in Hartlebury Printers, is that he was quite clear about the fact that the argument there by the had been a rather root and branch one,
yes,
to say that there was no obligation in relation to collective consultation. It wasn't the case about the notification, but the same principle. And he rejected that because it's an obligation on the employer. And so I do come back to the fact that we're looking at the employer, yes, and the circumstances attaching to the employer, rather than, it's not irrelevant, but the circumstances attaching to the obligations associated with the administrator. Because, back to my dilemma, if arguing against myself and the potential of arguing special circumstances, if you look at it purely from the position of an employer, an insolvent position, if it had the funds to continue to pay the staff to consult with them and make them redundant and give them notice, just to pay their wages over that particular period of time, it would be practicable, question mark whether it would be reasonable, for that notice to be given. But if you look at it from the perspective of the interest of the creditors as a whole, they'd be entitled to say, well, wait, why are you paying the salaries of the staff in circumstances where there is no basis for the continued interests of the business, other than that we need to shed those liabilities straight away? So that's why my dilemma directly impacts upon the existence of those conflicting duties. I was going to, although it's taken a long time, I've dealt with, confess, much of the argument I was addressing in the other part. So I say with some, hopefully, comfort, although technically that was the first part of the second part of my submissions of outline of the legislative framework. Don't be dismayed, I hope to be quicker in the other part, which is really a question of construction. And in truth, we actually say that the question of construction is much simpler, The legislative part that I haven't taken you to directly is, of course, the existence of those particular duties, but which rest upon the administrator, and those very briefly are articulated in Schedule B1 of the Insolvency Act, and it is worth simply turning up at page 214, paragraph 3, which is the heart of what we say are the obligations resting upon the administrator. Paragraph 3 setting out the purpose of the administration, and there is a hierarchical list of objectives, and the obligation upon the administrator is to perform their functions with those specific objectives. And subparagraph 2, as I've already referred to, imposes the specific obligation to do so in the interests of the company's creditors as a whole. And that, of course, is the heart of what we say is the dilemma. And there really isn't any disagreement between myself and my learned friend about the fact that the administrator is bestowed with powers to effect that. And although their primary status, as articulated under paragraph 5 of the schedule, is at 214, where the administrator is described as being an officer of the court, whether or not he's appointed by the court. And my lords, you'll be familiar with the fact that there are 3 routes, my dear friend's footnotes referred to into the appointed administrator. It doesn't really matter which of those 3 routes arise, acknowledging that one of those routes may be by the company itself. But I say the routes don't change the position that once the administrator is engaged, their duties look to a wider caucus than the company contributors or the company itself. And to do that, they're endowed with the power to act as the company's agent. That's at page 245.
Which paragraph is that?
So that's paragraph 69.
Ah, thank you.
Paragraph 69, page 245. In exercising his functions under this schedule, administrator of a company acts as its agent. It's a point we make in our case that it's not the same as a normal agent in the sense of appointed by the principal to act on their behalf. This is clothing the administrator with an authority to enable them to perform the objectives or tasks within the schedule. And my learned friend, and I take no issue, of course, with it, sets out a summary of various powers that exist in relation to the administrator's ability to do that, all of which, though, are channeling back to that obligation to the creditors as a whole to achieve those particular obligations. That really takes us to our argument, which primarily rests on what we say is a straightforward construction of the language of the relevant section. And in our case, this starts at paragraph 18, page 83 of the electronic bundle. We say as a simple matter of ordinary natural language for the purpose of the section that an administrator is not a director, manager, secretary or other similar officer of the body corporate. And we know clearly that they're not a director, they're not a secretary. We say they're not a manager in the sense that they are appointed within the company for managing its affairs. Their powers in relation to management are management only for the purposes of the objectives within Schedule B. That's the point we make at paragraph 21 of our case. So while they exercise management powers, they do so for a specific purpose, distinct from that, which might be described as being that of someone described as a manager. So the argument, in a sense, focuses on whether or not it's possible to describe the administrator as being a similar officer of the body corporate. Now, there's some...
and that wording goes back to the EPA 1975.
Yes. And you may say, why has this not been looked at before? So far as I'm aware, there have only ever been 2 prosecutions in relation to this, of which this is one. My learned friend, no doubt, will be able to correct me if I'm wrong about that, but it's an offence that's sat there, but has, until 2 prosecutions, one of which is this, has not really been the focus of any attention. So there's never been any case that's looked at the construction in this particular context.
So only 2 prosecutions, even against the employer?
Yes.
Right.
The other is a case called CityLink, involving the collapse of a delivery company, which was brought against the directors but not the administrator, and I recollect that they succeeded in an acquittal at the magistrates level. So to move on to paragraph 22, so the focus of the argument, as I understand it effectively, becomes that phraseology, similar officer of the body corporate, is an administrator an officer of the employer. And there's some forensic jousting between I and my learned friend on our respective cases about rules of construction. I think we all end up in the same place, effectively, which is the word similar suggests that it's a limitation to mean that it's intended to reflect only the class of individuals reflected in the previous express examples. It's not widening the group.
I'm not sure whether you... Clearly it didn't include administrators in 1975 because there weren't administrators then.
Yes.
So at the time it was enacted, it didn't cover administrators.
No, all liquidators who did exist in 1975.
Well, let's just stick with administrators. So the question is, now that administrators have been invented, as it were,
Yes.
Does this word encompass them, even though it clearly didn't at the time it was enacted? Has the meaning of the word changed to encompass this new creature?
Well, I suppose I turn it around and say the meaning of the word hasn't changed. The question is whether or not the creature, as formed and created in its power, in their powers by the schedule, fits in the definition. Has a creature been created that becomes an officer of the company? And what we can't see, it's a simple point we make at paragraph 10 in our case, and I suspect we're going to look again, as I'm invited to reply at section 212 for similar effect. What we can't see in the schedule is an express articulation that the administrator is an officer of the company. We're told they're the company's agent. What we're told is that they're an officer of the court.
I think if one looks at the leading cases on on ambulatory construction, the always speaking doctrine, the gist of a principle is that the meaning of a statutory language doesn't change, but the objects to which it refers may change as a result of external developments.
Yes.
So the meaning of words is the same now as it was in 1975.
Yes.
And the issue is whether this new entity falls within the scope of that meaning.
Yes. And the meaning in 1975 was that it was directed towards officers of the company. And that's a meaning that isn't changed, we say, in its normal construction. And to that extent, we say that the real question rests then in the nature of the role of the administrator, which it's a point I made, and it's a short point.
Can I just be absolutely clear that you're not making any submission that because administrators didn't exist in 1975, that's the end of the story?
I don't think I could make that submission because the Act has remained, it hasn't been amended. Administrators have come into existence. If they're created in a way that brings them within the scope of the section, then they're within the scope of the section. So my point is a different one, which is that they have been shaped in a way that doesn't bring them to be an officer of the court. An officer of the company. And it doesn't say similar person to an officer, it says similar officer of the company. So whatever one looks at from the construction, it has to be someone that one could properly characterise as holding an office of the company.
As to whether or not that person does, probably the most fertile source of an answer will be the provisions of the Insolvency Act that created the position of administrator.
Absolutely, which, as I've already said, is devoid of anything. And therefore, what my learned friend has to look for are powers that he says are similar to powers being exercised by those that do hold an office in terms of management, although, importantly, for entirely different purposes and clothed around someone appointed to be an officer. I make the point about at 22 Little Roman 1 about the lack of definition. It's worth just making the point, and I suspect it's probably where I have to look again at section 212 at subparagraph 3 over the page, at page 85 of the electronic bundle. We make the point about the language of the schedule, drawing a distinction between officers of the company and the administrator themselves. So, for example, we refer to paragraph 45 of Schedule B, which is at page 228. And that's a clause that deals with an obligation about documents issued on behalf of the company, and a requirement to state the name of the administrator and the fact that the company's administration. If you look at subparagraph 2 of clause 45, paragraph 45, you'll see that there's a distinction drawn between the administrator and officer of the company. So had it been contemplated that the administrator was an officer of the company, that would have been an unnecessary distinction to have drawn in the schedule. To similar effect, at paragraph 64, which is at page 242, of the electronic bundle, this deals with suspension of administrative powers, providing that a company administration or an officer of a company administration may not exercise a management power without the consent of the administrator. Again, inconsistent with the idea that the administrator is an officer of the company in terms of the framing of the language. I've already made the point which we make at paragraph 23 of our case back at page 85, that the nature of the responsibilities and duties of the administrator mean that they're not similar to a director, manager or secretary, in the sense that their duties are held to the company and ultimately only to its contributors, rather than being duties and responsibilities in the nature of the administration. So in our skeleton argument, I wasn't going to take you back through at paragraph 27, our second point. I've really already covered that in response to argument. That's at page 86 of the electronic bundle. Similarly, I've already dealt with the point about the position of the agent and how that's the point we make little Roman 3 on page 87 about the position of the administrator being not an agent in a traditional sense, but having a power of agency in relation to matters. These all go to the point that there's nothing similar about the nature of administration. Sorry, nothing similar about the status of administrator with those three parts. Can I deal with the third point we make, which is at page 88, paragraph 28 of our case. And that relates really to the argument that there's a lacuna left in terms of criminal sanction. I suppose in a sense here, I turned back on its head what the divisional court said against me when I articulated the existence of the problem for the administrators, where they said, well, if that problem exists, it's for Parliament. And my argument, of course, will be to say that if on the proper construction of the nature of an administrator, this offence doesn't extend to the administrator, well, it's for Parliament to change the definition and add them to the individuals. If the construction argument is there and there is no criminal sanction in relation to that, that's a matter for Parliament, not a matter for the construction of the particular section. We, however, say these points about the argument that there is said to be a lacuna, and they really run in this way. The first point we make is that there still is obviously an offence, and I acknowledge that's partially the consequence of my argument that it's only the administrator who avoids personal liability, subject to my Lord Richard's point about special circumstances. Even if the administrator is not within the definition, it's not a case of there being no sanction at all in relation to the failure to give the notice, subject to special circumstances for the company, because the company itself would have still committed the offence. So the only area where we're finding that there would be no criminal offence would be against the administrator personally.
Well, I mean, if the... Sorry, I was just going to say that if the proposal to make employees redundant arises only after the appointment of the administrator, and it has to be done quickly, then subject to being able to give notice within a truncated period, neither the company nor therefore the administrator would commit an offence. I mean, if on the other hand, the proposal had been formulated by the directors, and then pre-pack administration followed, well, then there could well still be an offence by the company and by the directors.
Yes.
So it's almost certain that an individual, well, it's very, in most cases, there will still be an individual liable. I mean, I can see that in theory you've got a case where the administrator has plenty of time to give notice, but doesn't, in which case you could have the company liable, but not the administrator. But in many cases, there will still be a personal liability, but it'll be on the directors.
Well, I take the logic. It's right to say, taking your conception of special circumstances in those particular circumstances, because the core special circumstances defence rests to that underlying offence of the company itself. If there were special circumstances that excuse the company and it was an administration, the administrator would not be liable to no one would be subject to a criminal offence at all.
That's true.
And it's true that that a position could exist whereby, and as I say, I don't represent the director, and he would no doubt have his own observations to make about construction in relation to these terms. It's true that it could be said that there might be a scenario where even in administration there was a liability in relation to the director if there'd been an earlier proposal that led to an inevitability, but I only accept that for the purposes of argument around the meaning of the words.
Of course, but the fact is, if there is a failure to give due notice by the company, there must be some human being in a managerial role in the company that will have given rise to that problem at the point where that person formed the proposal. That there would be the dismissal of the employees on the ground of redundancy.
Yes, well, I absolutely accept that companies don't exist other than through the entities that operate them. And when it comes to the directors, if there's a proposal to make redundancies, it will be those in that role that may have formulated that view. And equally, it may be the administrator. And equally, notice to terminate employment is not given other than by the exercise of a power by a human.
Yes,
and,
precisely.
And that may be the administrator. It's part of the powers that they have under administration explicitly to terminate contracts of employment, or it may be by the directors. And those are the two elements that are present in the context of the crime.
But at least in the context of the pre-pack, there must have been decisions made by individuals on behalf of the company. For example, my 3 factories, and they're going to ditch one to make redundancies in the context of an administration where the other 2 would be sold on to the preferred purchaser.
Yes, and so I'm cautious about that, but it's true that before the administrator is appointed, there may have been, in anticipation of that exercise.
Well, there must be. I mean, if it's a pre-pack, it has been pre-packed. So by the time the administrator comes in,
yes,
there is an agreed proposal to be implemented, and the administrator implements it.
Yes. In a typical pre-pack situation, I agree that would be the likely scenario, subject to anything changing at the point of their administration.
Well, clearly, it would depend on the particular circumstances, but as a generality,
yes,
there will be a human being or several human beings in the company who will have been responsible for putting together the pre-pack proposal,
yes,
no doubt with advice from insolvency practitioners. But they, of course, at that stage are not, on any view, administrators or officers of the company when they're giving that advice.
No. So at that point stage would never fit within the context of the definition on any view.
But the problem I have with what you've been submitting is you seem to be saying, well, there will be an offence by the employer, but there will not be the possibility of the accessory liability of any individual, because the only conceivable individual in certain circumstances would be the administrator, and they don't count. So there is going to be, I mean, the purpose of the criminal provision, as I understand it, is to impose the criminal liability on the company and, secondarily, on the human agency behind these particular decisions or failures to act. Now, what you're setting up is a scenario where there is a lacuna in effecting that purpose if the administrator does not class as an officer within the secondary liability.
I take the point of criticism, other than that I slightly disagree with it in this respect. So that may conflate two things, one of which I'm careful not to engage with. If one, for example, take my Lord Hodges' example of the pre-tac, it might be said that even in that scenario, I'm not conceding it, that the individual directors who were proposing, knowing that the notices will be given, are in the frame for the criminal offence, and there is no lacuna. Yeah. I'm not advocating a generic position that there is a sort of get out of jail card for those post-administration in relation to that. My objective is far more limited. It's to look at purely whether or not the administrator falls within that particular definition. Now, I acknowledge that it would mean that in a scenario where, let's say, there was nothing in the mind of the directors that engaged anything like a proposal, which in fact is what happened in Hartlebury Printers. It was found that there had been no principle. But when the administrator is appointed, they both formulate that proposal and formulate the notice. I acknowledge that I say that they are outside the scope and there is no sanction. There would be a sanction still against the company because this is a...
well, you've always got to show consent, connivance and lack of, whatever the phrase is, negligence.
Correct.
Yeah. But that there is somebody, if that person has the consent, connivance or negligence, you would have thought a purpose of the legislation would be to catch that person. But you're saying, oh no, there are situations where the employer will be liable, criminally liable, but there will not be, by just definition, anybody who can be held liable secondarily.
Yes, well, and I don't stray away from that in the context of administrator because it comes back to that fundamental proposition which was put to me about construction.
But it does leave a potential lacuna.
Well, that presupposes that you have to have a criminal offence against the administrator.
It depends what the purpose is, doesn't it?
Well, I agree that it lacks the purpose of having a criminal offence against the individual administrator, who I acknowledge is the only person in the administration who would have the ultimate authority to give the notice to the Secretary of State and affect any particular dismissals. But we come back to the same problem, which is the section predated administration. Administrator is a creature of statute. There's no amendment to the legislation to include administrator within the original definition. The proposition which is rightly put to me is, does administration create a creature that falls in the definition? It's not an answer, I respectfully say, to say that one has to distort the meaning of the language to create a criminal offence for someone who's not within the definition of an officer.
Well, the purpose of creating the criminal offence is to jolly well incentivise people to comply with the provision. You know, that's why it's made a criminal offence, to suggest that it's really, really important that officers do comply with this in what may well be a slightly chaotic situation. Now, is there any other source of an obligation to comply with or to give notice to the Secretary of State that is imposed on administrators through their professional rules or their codes of conduct or something? Is there something else you can point to say, well, no, they're not liable criminally, but look, this is what they're told they're supposed to do?
Well, there is an answer to that, and the answer to that is, which we pointed at in our skeleton. In our case, at page 22. Sorry, paragraph 28. Little Roman 3, which is the possibility of action against an administrator for misfeasance. But it goes a little further than
Sorry, where is that? Forgive me.
Sorry, it's on page 88 of the electronic bundle, paragraph 28 of the case.
28 subparagraph
2.
subparagraph 2.
And I didn't take you to the section there, but it is worth just turning up the section. I've got an eye on the clock, so I'm conscious of the time in relation to that. It's section 75, sorry, paragraph 75 of the electronic bundle, which is at page 250 of the electronic bundle. Paragraph 75 of the Schedule 1. So this is the court's power to look at the action of an administrator. So imagine that the administrator willfully failed to do this willfully, and we know that the company will commit an offence, and let's imagine that the company is then subject to a fine, that the cap on this particular fine for this offence is unlimited, but imagine the substantial fine is imposed upon the company. That will undoubtedly reduce the assets available for distribution for the creditors. So under section 75, a creditor, now I acknowledge that under subparagraph 2, the Secretary of State isn't identified specifically as an individual in relation to that list, although they may or may not be a creditor. The workers would be potentially creditors.
Well, the official receiver is
That's
listed,
true, yes.
which is, I mean, part of the same department that's before us now.
Yes, it is part of the
Effectively.
department, that is true. And they can bring before the court an application that, if you look at subparagraph 3, that the administrator has breached a fiduciary or other duty in relation to the company or has been guilty of misfeasance. So the administrator could be brought to task for failing to do that. And if you look at the recompense, under subparagraph 4, the court can order the administrator to contribute a sum to the company's property by way of compensation for breach of duty or misfeasance. So I'm not saying it's criminal, because it clearly isn't, but there is within the scheme of the legislation a mechanism of control of the administrator which provides an ability to deal with the truly errant disregard of those particular obligations.
And that circumstance probably would only arise where the administrator had adopted the contracts of employment, trying to keep the business going as a going concern, and then realising later on that he couldn't, at that point failing to give notice, because the only people who could possibly be held liable on any view would be the company and the administrator, if the administrator were liable, because the directors would have no control of affairs at that stage.
No,
and you're saying in those circumstances the administrator isn't liable, but could be hit for misfeasance under this provision.
Yes. So I can't give an answer to say there's another criminal obligation.
No, I'm not looking for another criminal obligation. I'm looking for some other source of an obligation imposed on a professional insolvency practitioner to comply with the spirit, if you like, of section 193, despite not being exposed to a criminal offence.
Yes. I mean, I'd also join generally to the fact that the administrator is appointed to be an officer of the court, and so beyond the schedule, there's also an obligation there's a power of the court to control their actions or take actions if they've acted in a way quite aside from this power that was considered to be. I mean, ultimately, I would say that it's not really a question of the breach of the notice, it's a question of whether or not they've ultimately failed to discharge their duty, which is to the creditors as a whole. But one can conceive of circumstances where one exposed the creditors to liability, exposed the company to liability because of a simple failure to give regard to the notice. It's a point I made earlier. There is no specific obligation There's no specific obligation under the UK to have imposed a criminal sanction. It predates all of this. We chose to impose a criminal sanction. The directive does not require a specific interpretation to ensure that a criminal sanction extends to the administrator. The only obligation, as I've taken you to, extends to effective measures of enforcement for workers.
No, I appreciate you've been answering our questions for the last few minutes, but I'm afraid otherwise your time has run out.
Absolutely. Can I only conclude by making this observation? What I haven't done, and I loftily hold it slightly at a distance, is taken you to much of the authority that we spent time looking around. I deal with that very simply in these terms. All of those cases, re-ex, home treat, properly regarded as they are in relation to the context, they're all dealing with a different set of factual circumstances in relation to this, because they're all dealing with a different statutory provision. And I respectfully observe in all those cases, including Johnson Builders, the court was looking to find assistance to the administrators in the particular interpretation. Ultimately, they don't help you at this level with the meaning of the Act, which has to be decided by the original wording of the section and what an administrator is for the purpose of that section. So I hold them light, even that which I rely upon Johnson Builders as saying we don't really need to be too much troubled by thrashing around in the undergrowth. Unless I can help you any further at this point, I apologise to my learned friend for eating up his time.
No, but I think the responsibility lies with us.
I'll take joint responsibility.
Very well. Thank you very much. Mr. Rosen.
My lords, my lady, I think I'm, if I may, going to divert from my originally planned order of issues and address, if I may, the last issue that has been raised by the court and addressed by my learned friend, which is the question of whether the learned friend's submissions would leave a lacuna.
Of course, it's a rather, in a way, it's a rather loaded term, lacuna. If we have to give effect to the meaning of the legislation, and if the legislation means that there is no criminal liability of an administrator because he's not an officer of a court, then so be it. That's what Parliament has enacted.
My lord, yes. But plainly, if the court was to come to the view that there was a lacuna which relates to the purpose of the statute, that would be an aid to the construction of the statute.
Well, there are two statutes, and the problem for you is there's the various provisions in the Insolvency Act which established the office of an administrator, and which draw a distinction between administrators on the one hand and officers of a company on the other hand.
My lord, yes. What I wished to do was to invite the court to have regard to the way in which we sought to address this issue in our written text. And it's in the electronic bundle at page 119, and essentially what we have asserted reflects some of the questions that were put to my learned friend by my Lord Burrows and by my Lady Rose. What we say is that leaving liability to the company alone is a manifestly inadequate solution, essentially for the reasons given by the Divisional Court. That the individual concerned with the default, that is to say the administrator in those circumstances, would escape a criminal sanction and would not be deterred from engaging in the criminal conduct. To put it shortly, it wouldn't achieve the purpose of the statute, which is to make the people running the company send in the form. And conversely, the company, which post-administration has no independent capacity to act would be liable to the penalty to the detriment of its creditors. And so we say in the result the offence would be a toothless one in the common context of collective dismissals. And we go on to say that that would defeat the purpose of the statute and the directive, and ultimately would be an unjust result. My learned friend, I think in answer to the question posed by my Lady Rose, went on to address the court on what my learned friend asserts could fill the gap in terms of regulating the behaviour of administrators, which is a misfeasance action. And we went on to address that question at our paragraphs 54 following on the same page. And we say that's an odd argument because it appears to assert that administrators are subject to the notification requirement to the extent that a failure to comply with it ranks as misfeasance, that they are not subject to the reach of the criminal liability in Tollricker that embodies the requirement.
But, sorry, I mean, they're not subject under the Act to the notification requirement. The company is subject to that. The misfeasance would be in causing the company to commit a criminal offence, which gives rise to a financial penalty in the shape of a fine, for which they could be made liable by way of reimbursement to the company.
But to which it would presumably be a defence to say, I had no choice because I didn't want to adopt these contracts. And it's in that context that the balance between the very important obligation under Section 193 and the obligations and duties of the administrator could be assessed in some way.
Yes.
I just going to raise this. I don't expect you to deal with it before the adjournment, but we've spoken about the possibility that the proposed redundancies might arise before the appointment of an administrator and actually have been decided on by the directors. In the situation where that hasn't happened and it's a decision taken by the administrators, can it be said that the employer, that is to say the company, has failed to give notice? I wonder. It's related to the point that Lady Rose just raised. If a company clearly has no control over its own affairs, I just throw that out there.
Lord, may I, as it were, take time to reflect on that point? I know that I have the luncheon adjournment ahead of me. I have a little list to consider. So I think what I may do is return to my original plan.
Before, just as it were, to add to really picking up a point that Lady Rose made, so you can add this to the mix. Administrators have to be licensed insolvency practitioners. They are therefore subject to professional discipline, as it were, by their regulatory body. Now, certainly one would imagine a deliberate or reckless decision not to comply with the statutory requirement is the sort of thing which might well, one would think, amount to misconduct on the part of an administrator. So when you said that if administrators are not, if they're not subject to a criminal sanction, they would not be deterred from performing their duty. That perhaps somewhat overstates it.
My Lord, I see the point, yes. They would be able to say that they are not subject to the directors, etc., liability provision. But as your Lordship indicates, that may not be a complete answer.
Well, what I had in mind, I must say, is that there must be a manual for administrators. This is what we do when we go in. And whether there's a paragraph in there that says there are these notice provisions, it may or may not be feasible for you to comply with them. You may or may not be actually legally bound to comply with them, but you jolly well should so far as you can, and that is your professional duty. Now, no one has taken us to anything like that, but my questioning was to sort of flush out whether anything like that actually exists.
Yes. Well, I can say, standing before your ladyship this afternoon, that I am unaware of the existence of such a body of material, and indeed had we been aware of the existence of such a body of material, we would have invoked it and relied upon it. So I suspect the answer is that there isn't one,
No.
although perhaps there ought
Well,
to
that
be one.
answers my question.
Individual firms who do a lot of insolvency work no doubt might have internal guidance, but
Yes.
to the best of your knowledge, there's nothing official.
Well, my Lord, as the court will be aware, there's a good deal of material available on the World Wide Web, and there's a lot of guidance that is now issued. Certainly this issue has been flagged up, as my learned friend indicated, as a matter that administrators need to have regard to. So to that extent, the answer to both the Lord's question and my lady's question is people are put on notice that this is a matter of concern that you need to have regard to.
We're obviously not going to go into it now, but there is a whole section on the BIS website on the Insolvency Code of Ethics, SIPs and guidance papers published by the government, by the look of things.
Well, my Lord, we will consider over the luncheon adjournment whether we have let the court down in not placing such material before it.
If it helps, it's on www.insolvencydirect.biz.gov.uk.
I would have thought it was more for Mr. Reed's client to say, look, I may not be included in this term officer, but I'm bound by these obligations and I'm aware of this obligation, but not suggesting that it's you who's at in default.
Yes. I was going to go back, if I may, to address the way in which my learned friend began his submissions to the court, talking about the hypothetical situation of an administrator coming in cold to an insolvency situation with a limited opportunity to scrutinise the financial position of the company. It is right to observe that many cases are different to that scenario, and on the agreed facts upon which the judicial review was decided by the divisional court in this case, this is one of those cases. Because those facts include the following: that considerably in advance of the company going into administration on the 13th of January 2015, in November of 2014, Mr. Palmer and his insolvency practitioner colleagues had been involved in advising USC's owner, Sportsbook.com Retail Limited, to discuss a debt owed to it by USC.
Can I just stop you? Do we find the agreed fact somewhere in the bundle?
My Lord, we do, but I have gone into, yes, we find it in the appendix. We've got a chronology, haven't we? No. My Lord, there is a chronology. Page 72 in the electronic bundle. But I am reminded that the example that I just gave is not included in that. It is, however, in the papers before you. One has to drill down a little bit into the case summary.
I mean, you said there were agreed facts. These were put before the magistrates and then before the Court of Appeal, were they?
The way in which both the magistrate and the divisional court dealt with the
Divisional
matter
Court, I mean, yeah.
was on the basis that the facts set out in the case summary should be agreed
I see.
for the purposes of the judicial review.
Thank you.
That they were to be taken at their highest for that purpose.
Right. I'm sorry, I thought.
And the fact that I just mentioned is to be found in paragraph 42 of the case summary.
And that's where?
That is at 197 in the electronic bundle.
Thank you.
And so the essential point, I'm sure the court has it, is that this was a case where the administrator was brought in to advise rather more generally long before the company went into insolvency.
I see. I see.
And this was a pre-pack case. Upon the appointment of the administrators, the pre-package sale of the business of USC was made to Republic.com Retail Limited, which was also, like USC itself, wholly owned by Sports Direct.
Yes, but I think you said that in November that Mr. Palmer and his IP colleagues were involved in advising USC, but the paragraph 42 of the case summary suggests that they were advising the creditor, namely Sports Direct.
Yes, if I said that.
I may have
Yes,
misnoted
I think in fairness, I noted you as saying they advised USC's owner.
USC's owner.
Certainly what I intended.
So I missed. That's my mistake. Thank you. Yes. So this was a debt owed within the group.
My Lord, yes. And what happened on the pre-pack sale was that the business of USC, excluding the warehouse business, which remained in the hands of the administrators, was concluded. Republic also being wholly owned by Sports Direct. And so, as the case summary puts it, and indeed as the judgment of the divisional court describes the matter, the effect of it was that USC, save for the warehouse business, was transferred from one company owned by Sports Direct to another company. The other essential fact, I don't think I need to develop it, which formed part of those agreed facts, was that in the run-up to the administration, steps were taken since early January of 2015 to remove the stock and equipment, fixtures and fittings, and to cease operations in the Dundonald warehouse. And so the two essential features of those facts, if they are ultimately accepted, are not untypical and are in contradistinction to the hypothetical case advanced by my learned friend, namely that the employers did or should have seen the insolvency coming, and that they took early advice from an administrator in the form of the appellant, Mr. Palmer, who was aware of the broad state of the financial position of the company on those.
Well, again, you say they took the advice of Mr. Palmer, but you said it was their owners, it was the employer's owners.
Oh, yes.
It was the creditor, not the debtor, who took the advice.
Oh, yes.
And this is before Mr. Palmer became an administrator.
This was before Mr.
Yeah.
Palmer became administrator. The essential point that I'm trying to make is that, like many cases, Mr. Palmer can be taken on those agreed facts to have had some knowledge of the company, as opposed to coming in completely cold
Oh, yes.
to it.
Yeah.
Well, I think those were my prior comments about pre-packs.
Yes.
I mean, the critical date appears to be for a meeting, the one in paragraph 41 on the on or about the 17th of December. I mean, all we know about the November meeting is that it was they discussed a secured debt.
My lord, yes.
So, I mean, you may, if this case goes to trial, you might want to explore that in cross-examination. But what then happens is that there's a statutory demand served on the 10th of December, and paragraph 41, UKSC had a meeting with Mr. Palmer to discuss it, the statutory demand. So that's perhaps really setting the scene more, isn't it?
So it's the 17th of December, yes.
Yeah.
It was the 17th of December, paragraph 41.
And what were the dates then in the prosecution of Mr. Forsey? What was the span of time that was covered? I've made a note.
Well, my lady, essentially, I may have to go back and remind myself of the precise position, but essentially the case was put on the basis that from at least early January of 2015, Mr. Forsey, as the director of UKSC, was responsible for those steps that were taken to effectively cause the Dundonald warehouse to be incapable of operating.
Right, but I think that when the charge is brought, there has to be a period during which it is said that the...
Yeah, well, one finds this in it's in the judgment of the magistrate.
Yeah.
In this hard copy bundle we have, it's on page 104. I think it's something, you have to add something like 67, so it might be about 171, something like that. It's paragraph 1.2 of the judgment.
So what's 4th and 14th
It's the
January?
4th to the 14th of January, so
Yeah.
far as force is concerned, and the 12th of January to the 5th of February, so far as Mr. Palmer is concerned.
Yes, so the 14th of January being the date of the administration. Yes. So this is, so it's charged as a continuing breach of the obligation to serve a notice.
Indeed it is, and I know that reflects some of your own observations earlier and questions that you raised. And the position is, yes, Mr. Forsey is charged with the default running from the 4th of January to the 14th of January, and then Mr. Palmer, one can see this at paragraph 1.3 that follows, is charged with an offence relating between the 12th of January and the 5th of February.
Which starting the day before he became administrator, but that may just be a slip-up.
Yes, it may be. I can't quite recall whether that was a slip-up of the district judge. But at any rate, the essential bifurcation is before administration and after administration. The 5th of February being the date that the Form HR1 turned up, having been posted, having been discovered
Yes.
through oversight, not previously having been sent.
And that then is the end date of the criminal offending.
The lady, yes.
Now, we're now some minutes past 1 o'clock. If we could adjourn now, we can resume our examination of the facts when we resume at 2 o'clock.